Hey everyone, it's Bradley Rosa with the Broward Bar Buzz. Today I'm happy to have attorney Ken Miller here of Haliczer, Pettis, Schwamm. Ken's going to discuss medical malpractice with us. There seems to be some confusion with Florida laws on what is and what is not medical malpractice. Welcome, Ken.
Thank you, Brawley. I appreciate the opportunity to be here.
So Ken, can you shed some light on how often people will receive medical treatment and the outcome is not exactly what they expect? They're not happy with it, and how that may not necessarily mean that it was medical malpractice.
Correct. There's a lot of situations where people have outcomes after they have involvement with the medical field, either an injury that lingers or they've got pain that they didn't expect, and everybody assumes that that's automatically malpractice. And that's really not the case. There's a whole, almost a system you have to go through of looking at things and checking boxes to figure out whether or not it's malpractice or not, as we use that term.
So I know that there's a statute out there somewhere we were talking a little bit about that tells you exactly what is medical malpractice. So can you explain that for us?
Sure. As part of the entire chapter on malpractice, there's actually a statute that says because you have a medical injury, that doesn't mean it's malpractice. In order to prove it, you have to do the things you would normally do, which is you have to show that somebody committed negligence, which in the malpractice field is called deviating from the standard of care. You have to show that they made a mistake, that they were below the standard of care, and that mistake actually then caused the injury that you're complaining of. It's kind of a almost three-step process, and you've got to have all three parts for there to be a malpractice case.
Now that you enumerated the steps, but let's say you hit all those steps, but that injury isn't permanent. Is that an instance where it could be medical malpractice?
It could, and it really depends on what it is and how significant it is and what the impact is. Because, for example, the damages that you can get are not just, for example, pain and suffering. You can have economic damages. So even though the injury is not permanent, say you suffer with it for a couple of years, but it causes hundreds of thousands of dollars in medical bills, that could lead to somebody wanting to pursue a malpractice case because there are damages, even though the injury at the end of the day may not be what's defined as permanent.
Okay. Give us an example of where again, you hit all the steps, but maybe the surgeon figures it out and corrects it, as you said.
So there are often cases where someone will go in for a surgical procedure. Let's say you're having your appendix removed. And somehow during the surgery, the surgeon accidentally cuts something he doesn't intend to as part of that surgery. But he recognizes it right away during the procedure, and he's able to fix it during the procedure before you even come out of the surgery. That's clearly something that's not supposed to happen. It clearly caused an injury, but that injury was repaired, and therefore no one's going to say that that's a malpractice case.
Often people get hurt and they automatically, I'm going to sue you. They think that they can sue these doctors. Can you illustrate some moments where people have been hurt, but it didn't rise to that level? Because there's probably common things that happen.
One of the most common is people that go in for surgery and they develop an infection after surgery. Everybody I talk to that calls my office thinks that if they develop an infection after surgery, that means somebody did something wrong, and that's not really the case. Most consent forms for surgery put on there that there's a risk of infection. In order for it to be malpractice, you would have to show somebody actually did something wrong to cause that infection. They either brought something that wasn't sterile in, they failed to use antibiotics. There are specific things where infections can be the result of negligence, but just because you develop an infection, even one that takes days or weeks to go away, that doesn't mean somebody committed malpractice. And that's a common call that we get in our office where people are looking to see if they've got a claim or not.
Are there some other instances that you can elaborate on that are common?
Yeah, and some of them are kind of almost obvious that they're not malpractice, but people call anyway. And I'll give you a perfect example. Everybody has had the situation where you have to go to the emergency room and people sit there for hours before they get treated because they're assessing the most serious people that they're taking first. And people are often very, very upset that they had to wait. And a lot of times, if you've got an injury, you're in pain while you're waiting. And people are like, that's malpractice. They made me wait. I suffered. That's not malpractice. That's unfortunate. That's part of the system, but that's not a malpractice case because you can't show somebody did something that was below the standard of care just because you had to wait in the waiting room in an emergency room. That's a common complaint that I hear, not only people that call my office, but even amongst my own friends and family and people we all know. Everybody's got that experience in an emergency room.
It's terrible and frustrating, but it still doesn't rise to that level.
No, it doesn't. Other situations, an example would be, if there is a delay in either treatment or the surgeon doesn't come in on the day that you're there, and eventually 2 days later you have surgery. Well, unless you can show that that 2-day delay actually caused you some additional injury, the fact that you had that delay, that's not malpractice. It's unfortunate, it's frustrating, but it's not malpractice. And those are the kinds of things that when people have questions and they call my office, we kind of look at the records and help them work their way through so we can figure out for them whether or not they have something that's worth pursuing or not.
Suppose you're in the emergency room and you're complaining about chest pains and they just leave you out there for that time because it happens. And you have a heart attack while you're in there now.
So chest pains are generally one of the exceptions in the emergency room. Most emergency rooms, they have what's called a triage system. You get categorized, most serious, least serious, who can wait. The things that are generally the most serious are people suspected of heart attacks with chest pain and gunshot victims. Like those people are usually rushed in right away. If you're there and you're telling them that you have chest pain and they make you wait and something bad happens, that is potentially a malpractice case because that is something they need to act quickly upon.
So what are the type of things that someone would have to consider, the layperson, when they want to come see you? Obviously, they should come see an attorney if they're not sure, but are there some points that they should be thinking about?
Well, number one, your first point is the correct one. If you've got questions at all, you're better off trying to talk to a lawyer that does this so you can get answers. Because even if the answer is you don't have a claim, it's better than having no answers. So what I tell people is, if you've got an issue and you've got a concern, whether it's a bad outcome, you're just upset, talk to a lawyer. There's no harm in talking because most lawyers in that situation, they don't charge anything for those calls and they can give you answers about whether you have a claim or not. If you truly do think that something has gone on and you have the ability to either get your records or documents, just make some notes so you have dates and times wrong, that's always good to do. So when you go talk to the lawyer, you can give them more information.
So Ken, can you give us other ideas, other instances where perhaps it could be potentially medical malpractice?
Sure. So one of the things is every scenario is different and you have to look at the totality. And part of it is you have to take into account the patient's history. You have to look at what the symptoms are. For example, we have a case we're looking at where a lady was a known diabetic and she came into the emergency room after having sustained a fall. And while she was there, they never checked her blood sugar, even though they knew she had a history of diabetes. She went home and 4 hours later she collapsed. And when the paramedics got there, her blood sugar was 1,500, something off the charts. So that's an example of where the history was important in addition to the actual symptoms that they were presenting with. The flip side of that is you're a diabetic and you're in the hospital, and for whatever reason, they don't give you your insulin on time. If nothing happens as a result of that, your blood sugars don't go up, you don't suffer an injury. The fact that they didn't give you your insulin when you were supposed to get it doesn't rise to the level of malpractice. So it's really a case-by-case basis that you have to evaluate. And when you have questions, you talk to the lawyer and the lawyer will go through each case individually. There's no one garden variety answer for all of this.
Seems, it's funny because I never thought of it this way, but no harm, no foul.
That is probably a good way to look at it. Most lawyers, certainly our firm, if you call us and you're asking for a consult, there's no cost to you to doing that. And if you can get an answer, even if it's not an answer you like, but you get closure on the point because you understand you can't do something, that's better than just having these questions sitting out there that you don't know the answer to. And that's one of the things we tell people is like, even if we can't help you with a malpractice case, we might be able to help you get answers.
And that's important. Any other types of examples you'd like to share with us?
Well,
Common ones.
The common ones are, if you have a radiology test and it's interpreted as normal and there's something there. Well, what determines whether you really have a case or not is what happens afterwards. If, for example, for whatever reason you have a follow-up test shortly thereafter and it's discovered, even though the first person missed that, it's not really a malpractice case because it hasn't caused you harm, even though it's a mistake. But in the cases where, somebody thinks that they've got a clean bill of health from an x-ray, and then a year and a half later, something shows up, that's potentially a malpractice case because the first person missed it. So again, it's really fact specific on all these cases, but the bottom line is, if you have questions, it's worth investigating.
Suppose your general doctor, you go in for your physical, gives you a physical, gives you a clean bill of health, and a couple weeks later, you drop. You have a heart attack or something happens seriously. And in that process, they find out that you had whatever, low this or low that. Could that potentially be medical malpractice in terms of your regular doctor?
It depends. And that's a great, it's a great lawyer answer, right?
Yeah.
But it depends. Because if you went there and, for example, your doctor did an EKG and it's normal, and he did lab work and your cholesterol's not off the charts and your blood pressure's not off the charts, even if something bad happens to you like a week or two later, it's unlikely you're going to be able to prove that that's malpractice. Now, if you were there and it turns out he did an EKG and he misinterpreted or missed that you were already suffering some type of heart-related problem, then yes, that's a potential case. So I'm repeating myself, but it's really not a one-size-fits-all evaluation. It really depends on the individual facts of each case, which is why we have to look at every case separately and with an independent eye, regardless of what the story is, even if it's a story we've heard before.
Ken, how can someone get a hold of you?
The easiest way to get a hold of us would be either through email or calling us. And our phone number is 954-523-9922. My email is kmiller@hpslegal.com. If you call, someone's always available to take the call. And every call we get, somebody in our firm evaluates. We've got a whole process where the partners look at every intake we get and make a decision right away whether or not it's something we can help you with and want to pursue further.
Ken, thanks for stopping by and educating us on this.
Appreciate it. Thank you.